You may remember one or two videos I did just recently about Prince Harry and his battle with the Home Office over the decision to revoke his police protection, and secondly, over the refusal to consider his offer to pay for police protection if it wasn't paid for by the state. You may also remember that I said that this may end up costing the taxpayer because the Home Office is having to defend it. But it gets even worse than that with new reports and a Freedom of Information request filed by The Sun. So for more on that, please stay tuned. Welcome back to the channel. So this video may open your eyes somewhat because there's a report in The Sun to Prince Harry possibly going to cost the taxpayer over £1 million. And there's also a reference here to a potential unspecified loophole as to why he might not have to pay it back if he loses. Now, it says that it's an unspecified loophole, presumably because nobody has divulged what that loophole is or any reason why he might not have to pay that. But I've got an idea, so I'm going to discuss that with you in this video. It's just a hunch, but I will explain what it is. But first of all, let's go to the news article here to give credit to The Sun where it's due. They say that Prince Harry's court cases might cost over £1 million and the taxpayer is going to have to pay for it. So it says here the bid to hire a UK police guard has cost £502,000 to defend when rejected last month. And this was from a Freedom of Information request filed by the Sun. However, he's aiming to overturn that verdict later this year. And to defend that, reportedly, Home Office officials are understood, according to The Sun, to be furious at the spiraling costs that he's forcing on them, because, of course, they have to defend it. They cannot just sit idly by and let the court make the decision. They have to defend this challenge. So this is also potentially going to cost over £500,000. Now, it further says here, astonishingly, Harry is only going to return less than £10,000 in court costs. The FOI request shows that last month left taxpayers out of pocket by 492. I think there's a minor typo there. 492,000, I think that's supposed to read, not 492 with a comma. 492,000, I think that's supposed to read. Sources told The Sun that the Home Office cannot get back the cost due to an unspecified loophole. Now, I can assist The Sun here, I think. Feel free to reference me if you do, anyone at The Sun. But let's move to what I think that unspecified loophole is. And I'll probably send the link to this video to The Sun news desk after this when it goes live. Now, there are two possible loopholes here, but one of which I can discount straight away, and the other one is a little bit ambiguous. But whilst I'm not a public law specialist, these are just two that I'm aware of. One of them is known as a costs capping order. Now, I can discount this pretty quickly because this is, by statute, only available where permission for judicial review, permission to apply for judicial review has been granted. What that means in English is that there's an application to ask the court for permission to have a substantive hearing about the issues underlying the claim. So the claimant will put together an application supported with evidence to say to the court at the first instance, I would like the court to consider the underlying issues of what we're arguing about here. The court will take a look at those, as was in this latest case with Prince Harry with his offer to pay for police protection. What that means is Prince Harry has said, I made an offer to pay for police protection. They said they're not going to consider it. I would like the court to consider whether that was right or not, whether they were right to discount my offer altogether of offering to pay for police protection myself. The court at that stage has refused that permission to have the substantive hearing. So I've explained that a lot more in my other video, but essentially that is why the first potential loophole against him paying these costs should really be discounted, because this is discounted by not having had permission to have the substantive hearing in the first place. So because that permission to apply for judicial review on that basis was rejected, there should not be a cost capping order for that. It's potentially possible for the original case to have the original decision to withdraw his police protection in the first place last year. It is possible that there is a costs capping order in that case. Obviously, I don't know if that's the case, but it's possible because permission was granted, at least in a limited sense, to that last year. Moving on to the second potential one, I have to issue credit where it is due here to Richard Turney of Landmark Chambers. And pulling up this document here, a very comprehensive overview of costs in judicial reviews. Moving forward here to this section at paragraph 7, he says, one important and growth area in terms of judicial review costs has been the protective costs order. A PCO seeks to limit or completely remove the costs risk to a claimant bringing judicial review claims, provides an important means of allowing a genuine public interest litigation to proceed, especially where actions are brought by charities or community groups with little funding or pro bono representation. PCOs reflect the fact that the cutting edge of public law, and there may be considerable risk and uncertainty in mounting what might be an important but ultimately unmeritorious challenges. However, this is not without its difficulties, because there's a checklist here which was set out by the Court of Appeal, which would ordinarily mean that this would fail as well, and there would not be or should not be a protective costs order in this case. The Court of Appeal in Corner House set out that, firstly, it could be made at any stage of the proceedings, so that would be check for number one, in that an application for a protective costs order could be made even before permission's been granted, or on such conditions that the court thinks fit, but provided that the issues raised are of general public importance. I don't think anyone can argue that as a member of the royal family, even if not a working member and has moved abroad, is of general public importance. He's a member of the royal family after all. Secondly, that the public interest requires that those issues should be resolved. I think there'd be a tick there on sub 2. However, I think sub 3 would meet difficulty. The applicant has no private interest in the outcome of the case. Clearly he does. Whether it's been argued very narrowly that it's not his own private interest and that it is purely that it is a general importance and a general interest and that it's not him personally arguing, I think that's a little bit tenuous, but I think sub 3 would struggle here. 4, I think, would also be difficult, having regard to the financial resources of the applicant and the respondents to the amount of cost that are likely to be involved. It's fair and just to make the order. Now, if there was an application for a PCO, then it would necessarily mean that either the court has discounted the need to consider Harry's financial resources per the Court of Appeal decision in Corner House, or that he's argued that he's impecunious, at least in comparison to the Home Office, and that the resources are totally imbalanced and therefore, compared to the Home Office, he is impecunious. I don't know. Or at the very least, that he might have argued that it is fair and just to make the order. Now, if some of you have negative feelings against Prince Harry, cast those aside for a moment and just think, a member of the royal family making this argument on principle in public interest, general public importance, is it right? Was the decision right that he ought to be able to pay for it himself? But even then, the arguments are counterintuitive in that his offer to pay for police protection cannot go hand in hand with being impecunious, unless it's on this narrow argument that it's fair and just to make the order. Who knows? I think that would meet difficulty. Sub 5, if the order is not made, the applicant will probably discontinue the proceedings and will be acting reasonably in so doing. Potentially, Harry may well have argued that he might discontinue the proceedings because he can't go against the might of the Home Office unless there is a protective cost order in place. Not so sure. Secondly, if those acting for the applicant are doing so pro bono, this will likely enhance the merits of the application. I don't know if lawyers are acting pro bono. Pro bono means for free. I don't think that would be the case, but it's possible. It might have been, we'll do this bit for free if we get work for other things, potentially. But that may have some ethical implications as well. So I don't think that would be the case either. Number 3, it's for the court in its discretion to decide whether it's fair and just to make the order in light of the considerations set out above. So overall, what this is saying, with thanks to Richard Turney here, what this is saying in summary is that the court can take all of those things into consideration and make a decision and decide whether or not to make a protective costs order to protect Prince Harry from ultimate cost consequences. Now, in this case, the article from The Sun appears to suggest that it's limited at £10,000. I'm not sure where I read that. I'm sure I read that somewhere. Yes, I found it now. It says here, astonishingly, Harry only has to return less than £10,000 in court costs. And this reportedly, according to sources talking to The Sun, that the Home Office cannot get back the cost due to an unspecified loophole. So if it is a protective costs order, I don't think it's a loophole as such. It's just an order of the court to protect costs in the proceedings, given the public importance of the case, of the application, and so on. There may be another loophole that I don't know of, I'm not thinking of. I'm not a public law lawyer. If there are any watching, help out in the comments, let me know, and I can have a look at that as well. And I just found this interesting, that there is probably some provision here that's going to cap those costs that he might be liable for, when the costs of defending this at stage 1 and stage 2 in a further challenge to the initial decision to refuse permission could cost the taxpayer over £1 million, according to The Sun, its Freedom of Information request and sources that it reports. So I thought that was an interesting discussion. I know it's relatively complex, even for non-public law lawyers to talk about, because it's a very complex area of law, very specialist. So I'm barely scratching the surface to give you an overview of what this really means. Like I said, if we have public law lawyers watching, please do join in the comment section. Email me, let me know your thoughts, or maybe even get you on the channel here to talk about it. In the meantime, I hope you found that interesting. Please smash the like button and subscribe. And as always, thank you so much for watching.